Welcome to the 9th in a series of 10 CLE webinars. The title of today's webinar is How to Handle the Most Difficult Divorce Mediation Issues. The presenters are Anna-Marie Pittella and William Frankenstein. Anna-Marie Pittella is a family law attorney, accredited mediator, and collaborative law professional practitioner. She has limited her practice to non-litigation resolution of family matters. Bill Frankenstein is an independent licensed psychologist who works with individuals, couples, and families, imagining, experiencing, and enduring divorce. Dr. Frankenstein is also a collaboratively trained and acts as a divorce coach and works forensically and clinically at the interface of family courts and psychology. Now, we were just a minute late joining because Bill and Anna-Marie and I joined about 20 minutes early before this started. And then just seconds before this started, Anna-Marie lost her connection. So we are with Bill and hoping that Anna-Marie will get back on either by voice or by video and audio. So Bill, I think we should proceed.
Sure.
And I'll be glad to help you in any way I can, either substitute or you just go ahead and present.
Yeah, and I would say, because, hi everyone, I would say that what everyone should know, Carl, we were going to talk about this, Anna-Marie is an extremely seasoned, experienced mediator. I am more on the front end. I have a 30-year career doing work almost exclusively around family court situations, but I've been an accredited mediator for maybe 2 years or so. So I'm on the front end. So a lot of my questions, I'm both a presenter and an audience member because I have plenty to learn. So when Anna-Maria finds her way back into the conversation, we will sort of reorder ourselves. I think that by way of introduction, I mean, the goal in mediation is to take people who are, for a variety of reasons, choosing to make their own decisions about how they want things to be post-divorce. And very few come in with a real accurate or clear understanding of what mediation is or what is even being asked of them. So I think coming in, it's always important, and it helps with all the difficult issues that this presentation is directed at. And just by way of digression, Carl had done a survey and identified a set of questions. We've categorized them: difficult issues that present in mediation around custody and parenting time, around financial concerns, process issues, and the types of resistances you see. So when you have people coming in who are not sure what they're coming into and not sure what is going to be expected of them, I think that we think that on the front end, very first things, amongst the first things that you do would be, one, to normalize their experience, to help them understand that many people at their stage of the process really don't know what is expected of them and what will their responsibilities be. So we try to provide them with an overview. And I think what you'll find is most people entering into mediation don't understand how much work they're going to have to do. To say, when you compare it to litigation, where people provide information to their attorney takes it and runs with it. Here, we give people lots of tasks and lots of responsibilities, and they should know that coming in so they can prepare themselves and work. So the question is, what is a difficult mediation? What makes a difficult mediation? I think that one of the things that will help is to understand that any difficult mediation, in my view, is difficult not because of one person or the other person, but difficult because of the couple or the people, and that there's this notion of systems that you can't really understand one person unless you understand the other person and understand how they relate to one another. So that part of understanding how to deal with a difficult mediation is going to be to understand that you're dealing with a system, a relational system, and that you will understand either person better if you understand that system or try to understand that system. So I think that, speaking for Anna Marie and myself, we always try to promote this concept that we're working together. We're there to help them work out their issues, to make the decisions. It's a joint project between us and them. We've educated them about their responsibilities. We've told them what are the steps that are going to comprise the mediation, how will it unfold, because we assume that they're naive and upset. They're either angry or they're fearful or any number of upsets, but that's what people are coming in. And the more that you can normalize that experience for them, the better. In terms of difficult mediations, there are a couple of possibilities that, before we even get into the specific content areas, we talk about what are the things a mediator can do, or what are the things a mediator should do to deal with difficult divorces. One is to educate that there is always the possibility of citing law, where it helps people understand, if you went to court type arguments, what's likely to happen? What does the law say? Not as a threat, not to strong arm people into settling, but on the theory that knowledge is important, and that they should factor that into their thinking as they negotiate. Basically, any difficult divorce is likely to have difficult underlying dynamics with the people. So sometimes co-mediation makes sense. Attorneys have a certain skill set, mental health professionals, which I am, have a certain skill set. It's very hard to find a mediator that has true competence in the law, in human behavior, and in finance. And so when there are difficult underlying dynamics, sometimes co-mediation involving an attorney mediator and a mental health professional mediator to kind of merge those skill sets and apply that to difficult dynamics. And of course, the idea that you then double cost is offset by, so Carl, just so you know, Anna Maria says you have her muted. Can you hear me, Carl?
I have her muted.
Yeah, that's what she just texted me.
Oh, okay. Let me just see if she's in the list of attendees. What telephone number is it?
Hold on, let's see.
732-842.
I'm going back to my contact list.
That must be it.
It would end, I think, in, you have one that ends in 1430?
1430. No.
6939?
No, I don't have a telephone number up here.
I'll find out what number.
I'm going to try this one.
Okay. And I'm just going to keep talking. Is that okay?
Anna Marie, unmute yourself.
Hello, I'm here. Oh my
Hey.
goodness.
Okay.
What did I miss? What did I miss?
We're ready for the Q&A.
We're all finished.
Oh my God. Well, I'm sure it was a wonderful webinar.
Okay.
So Anna Maria, I've basically on our agenda, I'm in the part with possibilities. I'm talking about co-mediation.
Okay, I heard what you were saying. I just couldn't speak. So.
Oh, okay. And let me finish the thought, and then we'll weave you in. So, and obviously, you know, one of the things that Anna Marie and I are going to push is consultation with others, to access collegial support, to read, to train, to take supervision as need be, but to certainly not be either ashamed or uncomfortable seeking consultative support with others who do this kind of work. So let me wave you in, Anna Maria.
Right. So everything that Bill said was absolutely true and incredibly insightful. And, you know, we all go through this when we have clients coming in. It could be the same problem we've had time and time again, but just a different client will state it a different way, or a client will have a different backstory. And so, you know, we struggle with how do we respond, how do we move it forward. And it still goes back to making sure that they understand, you know, what this process is all about, that they're the ones that are going to be structuring the terms that they'll eventually agree to, and we're here to guide them along, to prod them along, to ask questions, and to make sure that we understand what their situation is and what their questions are. So we should never feel that we're inadequate. We do, but let's try not to feel inadequate, and look for the answers in the best places where we can seek them. And as Bill mentioned, there's nothing wrong. It's absolutely best thing ever to contact a colleague and sort of throw the question out and sort it out. They're probably not going to have any one answer that's going to be acceptable, but you'll be able to thrash it out and come up with something that's going to make you feel comfortable talking with this couple and moving them forward. And it doesn't always have to be another mediator. You can contact a lawyer, and depending on what the problem is, you can contact a professional from another profession. So it's kind of thinking on our feet and being as agile as possible in responding to our own inner lack of peace when something comes up that we are not feeling the most comfortable in responding quickly as we might like to.
And what I would say, I'm sorry, go ahead.
No, I was just going to say I've worked with other mediators who are therapists. I've worked with mediators who are financial advisors, or I've just used them as resources to help come up with a solution or options. I shouldn't even say solution, options for a couple to consider. Go ahead, Bill.
No, we think it's just super important. Know what you don't know. And
exactly.
When you don't know something, ask for help. You will not be shamed, and in fact, it probably is good marketing to ask for help.
Absolutely.
You want to get across the idea that you do. Mm-hmm.
Yeah, the person you reach out to will probably be the person that contacts you when they have a question. So we're going to do broad strokes on some of these things because we got a lot of questions from different people. And what we tried to do is sort of categorize them so we can try and manage as much as possible, at least addressing some of the concerns that you've expressed. So the first category we have is custody and parenting time. And that was broken out even more specifically into different sections. So we had alleging poor parenting, which were safety issues, not abuse or neglect, but just things that may bother one parent more than another, or one parent basically just ignores more than the other. So things like bicycle helmets, or providing over-the-counter medications, or just different lifestyles in the TV programs they wear, or whether they should have peanut butter for dinner or not, those sorts of things. And then there's gross differences in important practices between the households. So, parenting styles, rules and regulations, those sorts of things. Getting the children involved if there's other professionals in their lives. So the children may be seeing therapists or doctors or whoever they are, and basically bringing those professionals into the situation as a third voice. And then communication and problem-solving deterioration because of their differences. So it just is an unending, irreversible, it seems, circle where they just keep going around and around in the same discussions without getting any resolution. Someone else brought out relocation, where it might be a person moves from for a distance, but not so much, not out of state, but a place where the parenting plan is impacted, or things that require more changes in the parenting plan because of where they've moved.
Yeah, can I add to that a little, Anna Maria?
Sure.
Because, when relocation cases are very difficult in litigation, they're very difficult for judges, and they're certainly difficult for clients. One person is asking to relocate with a child at a distance that will markedly change the day in, day out relationship with the other parent. And so negotiation around that has to start with an understanding of what is feasible, what is practically possible. Let's say one person moves to California and the other is in New Jersey. Well, what is even practically possible, and sketching out for them, helping them do the reality testing of what that would actually look like, as well as at least having a discussion. Can the parent who, if they stay put, the parent who would be being left, would they consider relocation too? Not all relocation requests are cynical. Many happen, someone gets in a new relationship, they get a new job, they need family support. There's lots of legitimate reasons to want to relocate. So you can have that conversation, even though it is extraordinarily likely that mediating a solution in a relocation case, that's going to be difficult, for obvious reasons.
And in reality, if this does go to court, each parent has to put forward a parenting plan that does contain practical ways that the parent who is staying in the area will still be able to see the child. So these are important discussions to have, hopefully, with a mediator, where you can reach something that works for both people, as opposed to have two dueling parenting plans proposed and then having a judge make a decision. So there's a lot to be said for this kind of homework, basically, to get done in a setting outside of the courtroom. So I'm not sure if Bill said this before, because I was half listening with my internet issue, but our point here is not to have answers for you, just ways of trying to deal with certain issues. So we're going to run through these topics to try and get through them in the hour that we have, and so it's not going to be very specific, but we are going to try and at least get your minds thinking in the direction that you need to with different problems that you've posed. The next section we had was special needs children. So it's parents who can't share the financial and daily caretaking burdens, problems developing their parenting plan, special demands of cross-home consistency, which is truly important for special needs children, disabled siblings and respite considerations, self-care for the parent who has maybe the majority of care for a disabled or limited child, and demands for better co-parenting and parent-parent support or collaboration. So, there's people who accuse the other parent of not being involved. There are parents who are accusing that the other parent doesn't even recognize that there is a problem for their child. It's all based on a lot of the behavior that they have had during the marriage, maybe just surrounding this particular issue or just other issues in general. And now recognizing something that is truly difficult and needs to be addressed, because the child needs to have the attention that he or she needs to flourish as much as possible. So, Bill, what do you think?
So what I would say is, there are special needs and then there are special needs. Just by way of illustration, I was describing a case. I had a situation where the child had something called Prader-Willi syndrome, which is a genetic disorder that has massive implications for parenting. These are children who, because of a genetic mutation, one of the things that's characteristic of a Prader-Willi child is they have insatiable appetites. And so they will go through garbage to try to find things to eat. You have to lock fridges. You have to make it so that they can't get into cabinets, because while they have reasonable lifespan and developmental opportunity, they grow into adulthood and stuff. The primary reason why a Prader-Willi child doesn't make it to adulthood is because of the secondary characteristics of morbid obesity. And so it requires immense effort on the part of parents. So you can imagine if you have two parents, one of whom is diligent on top of it and the other who is laissez-faire, that's not going to work for that type of special needs kid. Whereas let's say you have a kid with a mild learning disability, it does require parents to be speaking. It does require parents to have similar practices, but perhaps not identical practices, because the cost to the child is not going to be so great. So that I think that whenever you hear special needs, understand there is a very wide range of what that even means and what that even requires. And sometimes, this idea of differential roles, people may want to have a 50-50 parenting plan or something like that. But if the child's special needs are better served by greater consistency, that has to be, ultimately, in a mediation, the people will make the decisions, but part of your educative job is to sort of, if you do that, then these are the pros and cons. And I think with special needs children, these are very important decisions.
Yeah, so it sounds like it's important to know exactly what the special needs of that child are and who might be the best person that you can reach out to if you need to have more understanding of what the best case scenario for that child is, and also finding out who might parents trust to make recommendations for them, so that it's not that they're playing off each other, but they're listening to a third party who can provide insight as to the best parenting plan that they can put into place. People's lives are sometimes distracted by other things like work or school or other children. There's so many things that can impact on what you're actually available to do. So it is important to make sure that now in two separate households, you're still addressing the needs of the child. And I think for us, we were talking about, Bill and I were talking about, some reality testing, essentially having them look at different ways of doing things and what's the value of doing it one way versus the other. I think parents in this situation have to be encouraged, because sometimes it can be very demanding in terms of the lifestyle that they want to try and create. And I try and veer away from thinking of them as husband and wife, but more as mom and dad, and trying to encourage them to just think of them as mom and dad, and basically trying to put the best versions of themselves out there for their children. And they don't have to love each other. They don't even have to like each other anymore. They just basically have to do this job now of raising children that need more from them than might be in a typical situation. What's your thoughts, Bill?
Parents will always tell you that it is of utmost importance that they be their best version of their parenting or co-parenting selves. But the devil, of course, is in the details. And if you can, in the course of getting them talking, ask a lot of tell me more questions or soliciting details, asking them to envision what the future would look like. While you're doing that, what you will find is they start to lay out the pavers for their ultimate agreement. The more that they do that, the more that they see what they can do, what they can't do, and where the troubles are. And I think as a mediator, if you've got something like that going, I use this kind of tugboat metaphor, is this giant ship is coming into, say New York Harbor, coming into a harbor. Well, what the tug does is pushes it a little this way, pushes it a little bit that way, keeps the big ship in its lane just by nudging. And if you've got a good dialogue going, I think nudging people to stay in that lane will make your job much easier and will help them feel a greater sense of agency in their ability to actually deal with one another, parent to parent, and partition or compartmentalize out that part of their relationship that had to do with being spouses, which is, moving towards obsolescence.
And we talked about too how important it is that, if there's the parent who basically insists on doing it all, that the fact that the other parent wants to spend time with the children really is an availability to them for taking care of themselves. They need some respite. So working into the framework is truly an important thing for everyone. Child needs to see both parents. Parent who may be taking on too much needs some time to him or herself, and the children, need to know that both of them are working together as best as they can at any level that they can understand that.
Let me read the attendance code. Today's attendance code is 1137. 1137. Okay.
Go ahead. Can I just say one thing about
Yeah, of course. Go ahead.
This concept of respite. Obviously, as I said, there are special needs and there are special needs, but many special needs situations place enormous demands on functionally a single parent. And so respite is a very important concept for that parent, but there's also a large literature that you can access that talks about siblings of disabled children. And that, generally parents or the legal system tends to package children when they go back and forth between homes, that the children travel as a unit or as a package. And sometimes with special needs situations, and particularly in situations where the special needs, the satisfaction of the special needs is so dominant in the experience of the family, sometimes depackaging the children is really important, because you can provide siblings respite as well, because so much of sibling experience occurs under the umbrella of what the special needs child needs from parents.
Yeah, no, I agree with you. I'm glad you brought that up, because sometimes if there's so much concentration of a child who has some special needs in whatever level it is, the other child or children get forgotten. And they each need to have some personal time, special time, whatever it is, with each parent. So it does work in everybody's favor to impress upon parents how important that is. So the next category was financial concerns, and there's quite a few of those, so I'm just kind of run through them again quickly. Moving to two households when it seems to be impossible. One parent or one spouse, rather, being well-versed in finances and the other one having no clue. Asking questions like, why do I need alimony, or why does the other person need alimony? A couple who won't do the preparatory work for a budget or finances, or one of the couple not being able or willing to do it. Asking questions like, can we keep the house? Understanding how child support works, not that it's just the responsibility of the payor, the other household, but that each parent has an obligation to support the children. College expenses when there's little or no savings. Going back to work post-divorce when there's two households, and just to meet finances. And then property issues where there's a lack of understanding about how retirement funds work in distribution in the divorce. Or worst case scenario, and sometimes too common, is when there's no assets but only debts to divide. The reluctance of one spouse to leave the marital home, sometimes saying that the children don't want to leave their home no matter how old they are. Refusal to get a pension appraised and just using the amount that they've contributed to that pension plan as the value of the plan itself. Or issues, and this is kind of one that we don't see too often, I think, is if a couple or one of the couple has property in another country. Maybe it could be joint, it could be individual. It may be owned with other members of the family, and how does that sort of thing get addressed? So as far as most of this is concerned, I think it's educating the spouse who doesn't have the information first and foremost. Can't certainly make an agreement if there's missing information. So it's finding out what's the best way to help them reach the information or reach out for the information they need to make good decisions. Sometimes it's as simple as trying to figure out what the budget is going to be or the spending plan. There's so many people that don't have any idea of what they spent until they go to a divorce, and then some attorney or mediator asks them to figure out what have they been spending in the last year. And they have to go back and look at checkbooks and credit card statements and so on and so forth. It can be burdensome to do all that, and they just fall into a trap of just not wanting to do it or just not doing it. But there are people we can reach out to. There are financial advisors who do this all the time. Their job is to basically to plan out what the future is going to look to. So I oftentimes send clients to financial advisors who will sort out what they've been spending and what they need to spend. And frankly, it seems to come, the information comes easier to accept to a spouse when they hear it from somebody who has that kind of a background. So it's certainly a important piece to keep in mind where the burden doesn't fall on you. I know I became a lawyer because I couldn't be an accountant if my life depended on it. So I welcome the use of resources like a financial advisor for my clients. What about you, Bill? Any questions?
So, what I'll say is, I came into collaborative work and mediation work like many lawyers do from the litigation side, where I do historically have done a lot of the forensic family court evaluative stuff. And if you would have asked me before I got involved in alternative dispute resolution models, to me, divorce would have been 100% about children and 0% about finances. Because that stuff finances hardly ever comes up in that type of in forensic evaluation, except if one person is living in poverty, for example. But when I got into alternative dispute resolution, I realized that it's very different from what I expected. And it seems to me that as a generic consideration, that finances take up more of a mediator's time than custody and parenting time issues. And so from a mental health perspective, I think it's really important to have a basic grounding in the psychology of money, because when you start talking about people's financial concerns, you're talking about security and fear, you're talking about control and influence, reward and punishment, guilt, concepts of fairness, differential amenities and how that will play with the children, and people's own family histories of did they come from a wealthy family? Did they come from a bankrupt family? That all kinds of psychology enters into and informs that aspect of the negotiation. I mean, I think that's what I would like to get across, that you have to have some understanding of that, to connect with people.
Right, and on a practical level, people just can't make a decision on something that they don't know anything about, right? So if you don't know what you need to live on, how do you know if you need alimony? How do you know how much alimony you need? And sometimes people will just say, "Well, tell me what I should get." And that's not a question you can answer that way. It's really in the details of what do they need. Their decision is to determine what they want versus what they need, because if there isn't enough money to cover all of their wants, then they have to prioritize the things that are important to make sure that they have the shelter and basics that let them go forward. And it brings in, all sorts of questions in terms of whether or not they need to add additional income, whether or not they need to sell the house. Do they move from each having single-family homes to apartments or townhouses or whatever the case may be? But the starting point is, what do we have, and how does it look, and what can we do with it? The emotional part that Bill was talking about is extremely important. So asking questions about what their concerns are and what their fears are is important. Some of it is I think Bill will say, is vague. Other of it is grounded because maybe there was a divorce in their own families and they were left in a situation without the lifestyle that they might have had with an intact family. So all of those things bear on where this mediation in front of you can go or where it will go. And corralling it and putting it into the right path is really the job that we have.
I think that when let's say you're mediating and there are proposals on the table, one person wants $4,000 a month alimony, thinks that's what they're entitled to, and the other person is willing to provide $3,500 a month. So that $500, there's a real question. Will that $500 difference a month, so $6,000 a year, will that really truly be material in determining lifestyle, or is it psychological? Of course, the person who wants more always is going to argue the necessity, but so many of these discussions are really not about a number, but they're about security or certainty of lifestyle, and so understand that sometimes you need to find a way to make the issue what the issue really is that you're discussing, as opposed to that it's just a numerical difference and you keep moving towards the middle.
Right. And, divorce is difficult, so having a preconceived notion which may not be accurate is only going to make it difficult for everyone. So, again, I've said it before, but having them sort of assess what they really need versus what they really want is important, and having sometimes an advisor who can be objective, axe to grind on their part, they're just trying to basically come up with the numbers that work, is the best course.
I have a question for you, Anna Maria, because I've seen this happen a couple of times where only one person chooses to meet with a financial advisor on their own, so as opposed to the two people. So that one person goes to that financial advisor kind of views that person as like almost like they have a fiduciary responsibility that goes beyond just advising. And what I think that mediators have to be wary of is the outside financial advisor who pushes the person consulting with them to get as much as they possibly can, talks about entitlement as opposed to what you need and what certain numbers will mean in terms of lifestyle.
Yeah, ideally, it would be great if the couple agreed to go to the same advisor, but sometimes they don't want to do that, or for whatever reason. But I often find that once someone has gotten an outside opinion, the other party does then too, because then they feel they have to match or basically destroy what the other person has come up with. So we wind up getting there in some way, one way or the other. But the bottom line is to get them moving, right? Because if they're not talking, if they're not preparing their budgets, if they're not doing that kind of homework, then we can't get to the real decision of what's going to happen going forward with money and property. So the next category, I'm just looking at time here, is basically psychological resistance, which I'm sure Bill can give us a lot of information on. So the things that have been brought up were one of the spouses is emotionally behind the other party. One's ready to start the race. The other one is still tying their shoes, trying to decide if they even want to engage in getting a divorce. Someone won't leave the house. One party won't make any concessions whatsoever. One spouse keeps changing the situation so that you never complete any particular part of the discussion you're having. Mental health issues, whether it be substance abuse or otherwise, which either is not brought to light by the parties or it just doesn't want to be discussed. And personality disorders. We'll have our take on what that can be. I'm not going to be a diagnostic person, so I'm not going to name anything, but there's a lot of names that are bandied about in a divorce about the other person.
And I'll, the names never help. Putting labels
sure.
on, pardon?
For sure.
The names never help. What the real criterion is let's say someone is you would judge someone as a mediator. You tend to see them, or you've heard that they have borderline personality disorder. Well, you wouldn't really bring that into the mediation because one person is going to you will upset one person and you will cheer up the other person. The issue is not that they're borderline personality, but the issue is really what does that actually mean for the process. So they might be dramatic, they might be volatile, they might flip back and forth between that's the best idea that anyone's ever had for us versus that's an incredibly stupid idea. Where do you get your license? In Sears? And the point being is that if you label things, the label takes over. If you focus on the behaviors, that gives you something you can work with and move people.
Yeah, so we, Bill and I were talking about different behavior that comes up a lot in mediations, and it's sometimes to distract. It's sometimes just to become absent in the process, and it's things like people shuffle papers and they're not listening to you or the other spouse, or one spouse is always eye rolling the other spouse when something is said, or when the mediator says something, taking big sighs and looking up at the ceiling, all kinds of things that basically kind of divert their attention from the matter at hand. And it really is a matter of how do you deal with that? Do you ignore it? Maybe sometimes. Other times, do you try and name it, which obviously needs to be done in a very diplomatic way. Sometimes you can caucus with both parties, making sure that they both understand that you're not taking sides and you just wanted to get some private conversation to get more information for yourself. And you can bring some behavior to that person's attention. You know, sometimes habits just are habits, and they're not necessarily or always to minimize or degrade the other party, but they're just done almost unconsciously. But they have an effect, right? We all are triggered by certain things. So these are all things that you can be aware of and try and minimize as best as possible so that they don't interfere with the process. Reluctancy in any mediation process is always a problem because the other person clearly can get frustrated and trigger an end to the outcome, and then we are often running to court when otherwise it may not be in their best interest. So keeping in mind what their ultimate goal was, to come to mediation to resolve their issues, is important, and keeping it in the forefront.
One of the things I think that when mediations get difficult and it's the dynamics or the people are individually getting difficult, one of the things that mediators often resort to is caucusing strategies. And I'm curious, Anna Maria, what your perspective is on that. Good idea, bad idea, or maybe.
Yeah, well, I think it has a place. I'm not sure. I don't particularly like to caucus on a regular basis, but I do think it's a value if there's some further information that you need to get from one party, and it doesn't seem to be productive to try and have that questioning in a joint session. It's hard to say what's the most effective way. But, you know, you certainly don't want to give the other spouse ammunition by calling somebody out on behavior. So having that private conversation is, I think, more productive.
And you know, just I think that since this is nominally difficult mediations, we're assuming that we're dealing with a difficult person or more likely difficult people. And so the more difficult people are, the greater the likelihood is, I think, that a caucusing strategy may have unexpected inadvertent consequences, because what caucusing does by its nature is diminishes the transparency of the process. And if you're dealing with, let's say, psychologically complex or troubled people, that then becomes the issue, is the diminished transparency, not the rationale for meeting separately with people.
Right. So that's why one of the reasons I don't do it on a regular basis. And if I do it, I always invite them each to an individual session and basically ask for information that I'm not going to share with the other party, obviously, but just for my own purposes, to make sure that I'm not missing something, or I haven't heard something correctly, or I don't understand something that I think I understand, whatever. It's really for my benefit to try and help them.
So can we maybe go through process, and then we should go for questions?
Right. I think we have to do this quickly, too.
Yeah.
So a couple of people asked things about the chorus, the internet, the new significant other or another spouse who comes in to get involved in the mediation that's before you. Or sometimes it's the inner voice as chorus. And Bill, you can elaborate a little bit more on that.
Yeah, the person who has everyone they've talked to has, you know, you can get this, or you can get that, or you should win this, or, you know, that the person's head has been filled with all kinds of discrepant information from outsiders, and that then becomes the chorus. The person is no longer thinking for themselves. Or may not have that capacity to really think for themselves. You figure that out as you go, but the inner voice can become the chorus.
Right. So you almost feel like you're dealing with someone else in the room, even though there's no one else in the room except you and the couple. So what do you do with that, right? I think for a mediator, you have to obviously try and provide more specific information, because clearly what you get from neighbors, friends, family, internet, whatever, significant others, et cetera, isn't necessarily coming from an informative source. It may be based on more emotion than anything else. And getting the person who's asking the questions to a reliable source is important. So, having a list of mediation-friendly attorneys who can offer some insight into whatever the problem at hand is valuable. We're not supposed to be giving legal advice. We're supposed to be giving legal information. So one way of doing that is referring them to a mediation family attorney. The other is I give clients copies of the statute. If they're arguing about alimony, I give them a copy of the statute. They can read it. They can bring it to their attorney. They can see if it applies to them in their own minds or after they've seen an attorney, but that's independent information that they can use for their own insight. I do want to encourage people to have independent attorney review of an MOU anyway. They're going to be entering into a contract. I think that's smart to do. Not everybody will do it. That's their choice. You don't have to don't even have to get an attorney if you're accused of murder, right? We see that on TV all the time. But is it wise? Not so much. So I think it is important to get another set of eyes on any agreement that you're reaching in mediation. Invite them back. If their attorney has raised something that they didn't consider, that they have second thoughts about, whatever the case is, just invite them back to mediation and let them know when they go see an attorney that that's what they should do. So you can still keep working in the process they elected in the beginning to resolve their issues. Anything else, Bill, that you want to add on that?
No, I mean, I think that, the challenge for this webinar was to kind of catalog the types of difficult or challenging issues that mediators working in divorce come up against. And I think that what we understand is that virtually all of these are common to the experience of mediators who do this work. And that I think that you will find that in speaking with other people, you're going to get a lot of information about, when I had that situation, these were things we did, this is what I considered, this is how we dealt with it. I think that any of these, they're not esoteric issues, they're not unfamiliar in the experience, but it was interesting that all of our experiences of what constitutes a difficult mediation were very similar.
Exactly, right. I think there are many who are listening to this or watching this, if you have that luxury, since I can't, that they have experienced this. I've had a matter like that. I know the type of person they're talking about. So it's pretty universal. It's probably the fabric of the work that we do, and it's a matter of how the person brings it to your table or your desk that makes the difference. Some are going to go very smoothly, and others are going to have a few more bumps in the road. And either way, you just rely on your own inner resources or your outside resources to get you through different ways of handling the matter.
Anna Marie and I both understand that we've run through a bunch of things, and doing so normalizing your experience, but we probably have not given you answers, perhaps, in the way that you'd come into this hoping that you would have answers. Well, what if someone doesn't want to value their pension, or what if someone is rolling their eyes, or all the what ifs. And so both of us, Anna Marie and I, both invite you to reach out to us after the fact, should there be anything that you wished we could have gone further with, but you'd like to talk through. But please do reach out.
Yes, absolutely. Feel free. If there's something pressing that you feel either wasn't understood correctly or you want to add more layers to it, just give us a call. We'd be happy to thrash it out with you.
We
And
really
Carl,
only
have
have
any
a few
questions?
minutes left. And so I don't think we can open it up for general questions. Let me ask you a question, which is one I think that often is bothersome to mediators, which is that the mediation is going on in fits and starts. It's going on long. They're not doing their homework, which stretches things out. And in a sense, sometimes the mediator gets impatient with the pace of how the parties are proceeding. Now, is that the problem of the mediator, or should the mediator be doing something to be pushing it along?
Okay, well, I can tell you that in my very first session, I tell the couple that essentially the timetable is theirs. I've had people who have wanted to meet every week because they're at the point where they want that to happen. And then I have others that I'll see every 3 months, sometimes even every 6 months, and that's their timetable. So I leave it up to them to decide what they want to do. I do tell them I can't necessarily accommodate their schedule on a last-minute notice. I'm willing to work with them, and I will from time to time, if I don't hear from them, reach out to them just to see whether or not things have changed in their decisions to move forward, but I'm not going to pester them. So I've had situations where people come back, I don't hear from them for 3 months, even though I've sent them, little sort of updates or give me an update email, and then they come back. So, divorce, I think, is one of those things when you're ready, and you have to be sensitive to couple in terms of that. When one really presses, then I think they'll move forward if they're considering mediation their first choice.
If it's a question about the mediator becoming impatient, that says to me is if a mediator is becoming impatient with the clients, it could mean that there's something that the mediator isn't understanding about the dynamics, and so is becoming impatient because there's an absence of awareness of what's going on. And so I think that what I would say to a mediator is if you find yourself becoming impatient, maybe yourself digress, kind of take a step back and kind of think of the big picture and see if you can figure out where is the impatience coming from. What is it about the delay? Are they normative delays of busy people who have a lot on their plates, or is it delay that is due to avoidance or resistance or dependency or an inability to just do the task? So, I think that what I would say to an impatient mediator is first figure out what is trying your patience.
Okay, well, I want to thank.
I would just add.
Go ahead.
I was just going to add to that too that if you're an attorney mediator and in the past you've done other work besides mediation, we have a tendency to always want to be on top of things, and I think that might also create the impatience as a mediator. So, my 2 cents.
I want to thank both of you for, first of all, working through a rather difficult process with Anna Maria's video going out, but thank you very much.
I'm so sorry.
No, it happens all the time. You got to plan for it. So,
God.
There is one more CLE webinar this season, which will be on June 13th. That CLE webinar will be my last as the Director of Webinars for NJAPM. This, however, is the last on a divorce topic, so that is why I'm making this announcement now. I started doing these webinars in January of 2018. I've done more than 60 of them, including 7 Tech Time with Lawrence and Carl episodes over the past 4.5 years. Looking back, 2 things have struck me. The first is the high quality of the presentations that people have put on. My process for the webinars was to think of a topic and then find a person to present on that topic. I did not ask for an outline ahead of time. I did not review what was to be presented ahead of time, and the results could have been disastrous, but instead what we have are many, many, many outstanding programs. The second thing that struck me is how much I've enjoyed doing them. I've found these all just to be a lot of fun. I've met some good people internationally, and I've sort of amused myself by picking topics that I liked. So I know that Bruce and the board are in the process of finding someone to be the new director of webinars. So there will be a new webinar season starting this September. I thank you all for watching. I hope you've had as much fun doing or participating in these as I have. So I'll see you one more time in June. That will be a week later than is scheduled, and I will send out a note on that. But thank you again to our panelists, and thank you to everyone who's watched over the last 4.5 years.
Thank you.
Thanks, Carl. You've done a great job.
Thank you.